now that you've applied for your agreement, you're sending your application in. My gosh, Esta, what do we have to do to hire people? Because you can't have a dispensary without employees.
That's true, Eric, you can't. And that's a very important piece of it. So my name is Esta Bigler, and I direct the Labor and Employment Law program at the New York State School of Industrial and Labor Relations at Cornell. And we are partners with the Workforce Development Institute, which is a statewide organization that works in every single region of the state on workforce issues, to making sure that good jobs stay in New York. And so we've sort of come together as two sides. So we have the workforce development side, and we have the legal side that we think really makes the best combination for dealing with the issues in cannabis. And so I'd like to, in my hour, essentially give you an overall perspective of labor and employment law in the city of New York and in the state and in Buffalo as best as I possibly can. This is really just going to be an overall look. And if you have questions, please let me know. If I say something that you don't understand, please let me know as well. So let me share my screen and let's see if this actually works. So, okay, now, of course, it's not letting me go forward. Oh, all right, let's try it this way. Okay, so why are we here? We're here because cannabis has really, the legalization of cannabis has really changed the landscape in New York State, and it is certainly changing the landscape in the country. And we're going to get to President Biden's pardon in a few minutes. So in order to understand where we are at this really pivotal point in labor and employment law, I wanted to give you a quick overview of the history of cannabis. And then I also wanted to start talking about employer and employee rights, because I think you can't talk about one without the other, rights and responsibilities. So I don't know how much all of you know about cannabis. So just very quickly, it's a very complex plant. There are many variations. People call it by all sorts of names. We even spell marijuana in two different ways, with an H and with a J. The most important thing to know about the plant as we're thinking about it today is the THC, which is really the chemical that has the high that we think about with cannabis. In addition, hemp is also cannabis. And so sometimes when people talk about cannabis, they mean both the plant that can give you a high, and they're also talking about hemp, which has a lot of industrial and medicinal uses as well. A quick history for those of you who haven't been able to keep on top of all of this. The most important statute I will mention, and I promise you, this is not a law class, and I'm not going to turn you into mini lawyers. I don't need any competition. Is the Controlled Substances Act of 1970. That act is federal law, and it was passed by Congress and signed by the president at that point in time, and it regulates drugs, and it criminalizes marijuana. It has a schedule within it. That schedule starts as Schedule 1, which is a felony to encourage the use of that item, and it has absolutely no medical socio-positive things to it. That's where they've put cannabis, right next to heroin. Right next to heroin. Now, there are other scheduled drugs, and you can go all the way down, but at this point in time, that's where we are, which makes life difficult, because since it is a violation of federal law to use it, to sell it, etc., banks, you can't deposit money in a cannabis bank account because the banks won't touch it. You can't use a credit card to pay for cannabis, again, because the banks won't touch it. Federal credit unions won't be able to touch it. We are beginning to see the development of some state credit unions. However, that's few and far between. So starting a cannabis business is difficult. And so that's where we see big operators from out of New York State which have money that they're bringing into the state, could override what I hope to see is the social equity pieces of cannabis. The New York State drug law in 1973, I'm not going to talk about the federal law, the New York State drug law, again, that's where in our state with our legislation, we saw mass incarceration and the criminalization of cannabis, and judges had no choice. So what we wanted to do with the Compassionate Care Act in 2014, and when we'll talk about it with respect to the Marijuana Taxation and Regulation Act, was to undo what's happening on the federal level, as well as finally, when, certainly the draconian drug laws that Rockefeller put into place were repealed in 2009, we still had a whole bunch of years where nothing was happening in the cannabis space. So first, we had, as you just heard a few minutes ago, the establishment of the medical cannabis program, which was a big opening for us in New York State. And then, of course, we had MRTA in 2021. It legalizes adult use. There are going to be regulations from the Office of Cannabis Management, which is dealing with from seed to sale. And these regulations are coming out slowly, but they are indeed coming out. And it really requires, as we just heard, an LPA, for example, if you're applying for a license, you have to have signed a labor peace agreement. I'm going to talk a little bit about some of those requirements in a minute. Many of you may have heard about the federal pardon, which just was announced by President Biden this week. Everybody got very excited. It impacts 6,500 people who have federal cannabis convictions. The MRTA expungement of people's records involved 400,000 records being expunged. So you see the difference. However, it's a step in the right direction. And our hope is that with the president telling the FDA and the Justice Department to take a look at the Controlled Substances Act, we might see cannabis moving down as one of those controlled substances, which again will make life easier for all of us who see cannabis as a really important new industry in the state. We're talking about 30 to 50,000 new jobs being created in our state. And we want these to be good paying jobs where people are respected, they have good benefits like was just discussed, health insurance, all of the kinds of things that you need to be able to feed a family. So let me take you to MRTA for a moment to just give you a quick understanding of MRTA. As I said, it legalizes adult use from seed to sale. It expunges people's criminal records. What does that mean? That means if someone asks you, do you have a criminal record? And they're, with respect to cannabis, you can say no. You can't say that for a pardon. A pardon just means you've been pardoned, and the president's pardon unit is going to be sending you a piece of paper that says you were pardoned of a federal crime. But our MRTA law says it doesn't exist anymore, which is really important. We'll have oversight, as I said, by the Office of Cannabis Management. You will have to be licensed to work and own a business in this field, not work, but own the business in the field. We just heard about LPAs. It amended the New York State labor law, which says that employers cannot discipline employees for the use of cannabis outside of work. We know cannabis stays in your system for 30 days. So it really goes to the whole question of drug testing. Can't do it anymore. It has no validity in terms of you not supposed to be able to do your job. And that's going to make major changes in the workplace. In addition, MRTA recognizes the social inequality that mass incarceration has brought, what the criminal legal system has done in terms of really hurting whole groups of people of color in our society. And the goal of MRTA is to have 50% of the adult use licenses granted to social equity licensees. That's MBEs, WBEs, service injured veterans, indigenous people, etc. So the act is really there as a social equity act across the board. MRTA will impact everybody, employers, prospective employees, and to be successful, we really want to see and I know this is what 338 wants to see, is an equitable, fair relationship between the employees and between the employer. So a quick moment to teach you a little bit about the law. Federal law sets in many areas of labor and employment law the basics. It sort of provides the bottom level of protection. In some places, federal law prevails and state law can't change it. So, for example, under the National Labor Relations Act, which involves the relationship between unions and employers and organizing, et cetera, that's federal law. But often state law can give you more benefits and more rights and also more responsibilities than the federal law gives you. An example of that will be, of course, cannabis. Cannabis is a perfect example of the state law giving you something that at the moment federal law certainly does not give you. In addition, when we talk about preventing discrimination, you'll see that state law gives many more protections than federal law does with respect to discrimination and sexual harassment and hostile work environment. So federal law, we have Title VII, we have the Americans with Disabilities Act, we have the Age Discrimination Act, we have genetic testing. You'll see in a few minutes, we have many more protected classes. However, it's all in one law. So you don't have to go from law to law, for example. Then you may have local laws. If any of you are from New York City, you know that we have special laws in New York City about how to handle criminal records when you're applying for the job. So does Buffalo. So does Rochester. So you can have a local law which changes things. These laws have to be interpreted, and agencies like the Office of Cannabis Management and the courts will interpret the laws. In addition, agreements. What kind of agreements am I talking about? Collective bargaining agreements. Collective bargaining agreements give more rights and more protections than the law gives. That's in fact the whole purpose of having a collective bargaining agreement. And I would actually switch this. This is an interesting triangle that was developed in our office. Policies and practices. Employers on their own could indeed give people more rights than they have at all. So that's the triangle, and I wanted to sort of give you a sense of how the law sets itself up. So we have federal law, New York state law, give employees the right to join unions and engage in collective bargaining. We just heard about all what can happen in a collective bargaining agreement. It covers wages, hours, and working conditions, and that employees cannot be discharged without just cause. Let me just add a little piece there. We are an employment at will state. So just to sort of bring that out a little bit more, that means you can be fired for a good reason, a bad reason, or any reason, as long as it's not an illegal reason, and we're going to talk about those, or you have a protection in your collective bargaining agreement, which says you cannot be discharged except for just cause. So these are the things I would like you to think about as I'm speaking today, but also in your whole situation. What are the rights and responsibilities you have as an employer? What are your rights and responsibility as an employee? And what do you want to know? And who should you seek advice from before you act? And purpose today is to really give you a framework to begin to think about what should you be doing before you act, whether you're an employer or an employee. I'd like to cover today all of this. Some of it I'll be able to cover in much more detail, and some of it I will not. I'm thinking about it as Sunny wants to start a business. So as Sunny looks at opening up a cannabis business, what does Sunny need to know? Or I am Allie, you are Allie, or you're working with Allie. And Allie is seeking a job in the cannabis industry. What does Allie need to know about compensation, time off, benefits, discrimination, criminal records, privacy, and safety? What do you have to think about as you move forward to do this? So these are the questions we're going to try to answer today. What information can be asked on an employment application? What should people be paid? Now, if you have a collective bargaining agreement, that's in your collective bargaining agreement. But absent a collective bargaining agreement, what do people need to be paid? Can employees be paid when they take time off? What if their own sickness, a child, voting? You know, November is coming up quickly and there's going to be an election. What if an employee gets hurt at work, discriminated against, special needs, privacy rights? What if my workplace is not safe? And the one I've already answered for you is, can an employee be fired for any reason? And we've already discussed that one. So compensation, leaving aside a collective bargaining agreement. Time worked is time paid. If you work, you need to be paid for it. We do know that in other parts of the country, people were being paid in weed. They were not indeed being paid a salary. They were not being paid wages. That's not going to happen in our state. That is just not going to happen. So this wages, though, is a good example of where the federal government provides a floor and New York State builds upon that floor. So the federal minimum wage, can you believe it, is $7.50 an hour. It's outrageous. New York State, we have higher rates, and I need to tell you that as of December 31st, 2022, the rate in a good part of New York State is going up. In New York City and in Nassau and Suffolk, it's $15 an hour. That's staying $15 an hour. The rest of the state is moving from $13.20 an hour to $14.20 an hour. So it's moving up, and eventually the entire state will be $15 an hour. If you're an employer, please, two things: keep good records. Wage and hour lawsuits can kill you. New businesses that don't keep good records and can't prove that they've paid well, in terms of what the law requires, can be sued. And paying back pay and penalties for it is something that will put a new business right out of business. So please keep good records. And if you have an employee who's going to be working on December 31st, 2022, you have to pay them the new rate. It doesn't start the day after, it starts on that day. So please remember that that's what you need to do in terms of wages. Now, time off. Under federal law, we do have the Federal Medical Leave Act. However, you cannot be paid under that at all. Here's another example where New York State's better. New York State has its own Family Leave Act, and you are eligible after 26 weeks of employment to get paid leave. And what you'll be paid, now again, a collective bargaining agreement will be different, but what you'll be paid under the law is 67% of your salary to a maximum of 67% of the statewide average weekly wage, which in our state, by the way, is $1,450.17. So you do have that. I just wanted to note that voting, you don't have to be paid for voting. However, you can get time off to go vote if you give your employer 2 hours notice and you have less than 3 hours after the time you're come out of work and the polls close. So if you have 4 hours after the polls close, you can't get the time off. If you only have 3 hours after the polls close, you can be paid. So this is an area to just sort of keep aware of. And obviously, again, everything can be different in a CBA. Please, if you are a new employer, you know you have to be involved in the federal Social Security system, which means you have to pay into that system, and so does your worker. You also need to pay into the state unemployment insurance and the state workers' comp system. A worker does not get paid UI, unemployment insurance payments, if that person is discharged for cause. And there are hearings that will be held where you say, no, he should not, or she should not get that money that has been paid into the system. And the employee says, no, I was laid off. And so there may be a hearing that you'll have to come down to before an administrative law judge. Similarly, workers' comp works the same way, and there's a schedule in terms of you being injured on the job. Workers' comp only is there for workplace injuries. One new area that's going to be interesting to watch is COVID. And people are claiming that they got COVID on the job, and is that compensatable under the workers' comp law? And in fact, there have been some cases involving that. That could be a whole other workshop, but just to put it into your mind that I want to make sure that you don't not think of these. They are really, really important. Okay. Discrimination and harassment protection. This is really a really important piece for all of us to be aware of. As an employer, you are responsible for your employees. You are also responsible for your supervisors. As an employer, you are responsible if any of your employees or you discriminate against someone who comes in to purchase something. So while we think of this always as employment, it is also a public accommodation issue. So I wanted to go through with you the fact that under Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, the Age Discrimination and Employment Act, GINA, which is the Genetic Act, what that covers and what New York State covers, which is much, much broader. So the things that New York State covers, which is not covered at all by the federal government in any of the statutes I just mentioned. For example, gender identity or expression. There is indeed a Supreme Court decision which says that it is covered under Title VII's prohibition against sex discrimination. However, we're beginning to see that the EEOC's regulations on how that is to be enforced being knocked down by the federal courts. So it'll be interesting to see what happens with respect to gender identity or expression. But in our state, it's specified. So that protection is there. And that's important in terms of you as an employer or you as a worker. Those are protections that you have. In addition, where if you look at familial and marital status, that's not covered by federal law. That is covered by New York State law. Are you a single parent? Are you being discriminated against because you are a single parent, for example? Arrest and conviction record, not covered by Title VII. The only way it is covered under Title VII is if, for example, as an employer, the employer hires white people who have a criminal record, but not people of color with a criminal record. That is called disparate treatment. If you treat one group differently than another, and it's based on who has a record. So you treat one racial group differently than another, or you treat men differently than women. You'll hire a woman with a criminal record, but you won't hire men with a criminal record. Again, it's really not really based on the criminal record piece you see. It is really based on treating someone differently based on their color or someone based on their sex. Those characteristics that are already protected classes under Title VII. So again, our state's better than that. Victims of domestic violence is not protected under federal law. So again, we do better in our state than happens on the federal government line. And so we all do predisposed genetic characteristics. You cannot discriminate based on all the terms and conditions of employment. And that means hiring and how you treat applicants, as well as how you treat people during the term and condition of their work. So putting all the women in the back, term and condition of employment, giving people of color all the worst crappy jobs, term and condition of employment. So all of that is protected by federal law for those characteristics, and by state law, which has a much broader set of characteristics that are covered. The other difference between the laws, and you have New York City has essentially the same protections as New York State does. I suggest that if you live in most other jurisdictions to check to make sure, but no matter where you live in the state, you are covered by the New York State law. You're absolutely covered by the law. And so you have better protection there. On the federal level, by the way, you don't have an administrative agency that you can make your complaint. They have a judge, they hear the complaint, and it gets adjudicated. In the federal system, most of the time, except if the EEOC, which is the agency that enforces that law, sees a pattern in practice that they want to deal with across the board, you got to go get your own lawyer and go prosecute a case in federal court. So using the state system is a much, much better system. And again, our state has better laws. And I will say, as an aside, one of the things that I want to make sure happens when multi-state operators begin to come into our state, and they're waiting, that they understand that the protections in our law are better than the protections they may be used to in the state in which they've practiced, and certainly under federal law. Let me first take a look at some things which are public accommodation on both sides, which I want to make sure those of you who are planning to open a dispensary, for example, a retail operation. So let's look at disability for a moment. Disability covers employees. And so what the law says, if I am your employee, that you have to make reasonable accommodation to my disability. Well, what does that mean? That means, for example, if I need a computer that I can speak into or can speak to me because I have a sight problem and I have to hear it and I don't see well enough, I am sight impaired, and so a computer. The question is always undue hardship. Is it so expensive for the particular employer that that employer can't afford that kind of computer? Given how cheap those computers are these days, unlikely. But that's an example of a kind of reasonable accommodation. So another reasonable accommodation, for example, might be to make sure that your employee who is in a wheelchair has access to get into the location where he or she works. Now, let's go over to a retail operation for a moment. Is there a step to get into your store? Then it's not accessible. Then it violates the public accommodation piece, where your accommodations as being open to the public, you have to put a ramp in. You must put a ramp in so that if I am in a wheelchair I can get into your store. In addition, the aisles in your store must be wide enough so that I can be able to access the store. And sometimes the requirement is that there's a bell outside the store. If in fact you can't manipulate the ramp for some reason, there's a problem. So we think of these things as things which are required, that you must have reasonable accommodation for an employee who has a disability, no matter what the disability is. But you also can take that and look at it as a public accommodation issue, and making sure that a person has the ability to get into the store, to see what they want to see, and to be able to purchase whatever it is they want to purchase. So sometimes what looks like only an employment issue is really also a public accommodation issue as well. Similarly, I talked about disparate treatment based on somebody's race, for example, treating one group differently than another. The same thing is true in public accommodation. So if a white person walks into the store, nobody pays any attention. If a person of color walks into the store and all of a sudden someone is following them around the store, that's a violation of the law, because you're treating one group differently than you would treat another group. Again, that's a public accommodation issue. So while I'm talking about employee, employer, and employee, I want to be clear that this absolutely impacts you as an employer in your business, to make sure that those requirements, that you meet them for the public as well. It's why you see on public buses, the ramps to get on a bus. And there was a big lawsuit in New York City about having curb cuts. That's a public accommodation issue. Make sure that people who are in wheelchairs can get on the sidewalk and get off the sidewalk. So those are the kinds of things that will impact there as well. I'm going to talk about criminal records in a few minutes, but again, I want to be clear that all of these things impact both sides of whether it's an employer or an employee. There are two kinds of discrimination, and I just want to remind everybody. One is the one I talked about before, which is disparate treatment. That is treating one group differently than another. And you will see that issue of disparate treatment in a unionized setting as well. One of the things that will come up is the employer treating white employees differently than Black employees, women differently than men. So I can be late because I look like me, but someone who doesn't look like me can't be late. So these always, they come into play, whether we're talking about in the workplace that's unionized, or if you're dealing with a public law like the state human rights law. It's the same issue. It's important to know about that. There's another kind of discrimination, which I just want to mention because I think it's just important. And I love the facts of this case. It's one of my favorite cases. If you walk around the city of New York, you will see many short police officers. They may be Asian, they may be women, they may be Latinos. The city of New York once had a requirement that to be a New York City police officer, you had to be 5'8" or 9. Well, that's great. However, most women do not get that tall. Most men who are Asian or Latino do not get that tall. So the result was that you had essentially a tall white male police force. A lawsuit was brought, a lawsuit was brought against the New York City Police Department to say that height was not job related. What did height have to do about my job as a cop? And the question was, what are the essential job-related functions of this job? And it was conflict resolution. The police department argued you had to come in and be tall and be able to make sure that people respected you. All of the scientific evidence showed that what you needed to be was a good communicator and someone who could take a very difficult situation and calm it down. Because statistically, women, Asians, people who are Latino don't get as tall as 5'8" or 5'9". There was no intent to discriminate. No intent. No one said the police department meant to discriminate, but it had the impact of discriminating. And so the result for that kind of discrimination is called disparate impact. And I think I tell you that story, one, because I think that it's just important to know that that kind of analysis exists, but also because it goes to the very important question, which comes up over and over again, is what are the essential functions of the job? What has to be done here? So whether we're talking about criminal records in a minute, or we're going to talk about disability, what is job related? What are the essential functions of the job? And in that case, the essential functions, of course, have nothing to do with height. Just as the essential functions may have nothing to do with having to provide reasonable accommodation for a particular disability. And when we get to criminal records, we'll talk about it there as well. Okay. Any questions? I know I'm doing a lot of talking, and if somebody has a question, please let me know.
There was just one question I'll rephrase for you, Esta.
Okay.
As some of our folks are looking to file for their applications and they want to abide by all these laws, what sort of I guess law firms should they be looking at? The question was what law firm, but I don't want to suggest them. But
Right.
you know, as folks are out looking for legal help to make sure, you know, is there special lawyers that they need, or what would be your recommendation?
Well, I think there are two different kinds of lawyers. I mean, one is if you're establishing a business, you're going to need someone who's going to be able to give you the corporate law advice to decide what kind of corporation do you want to be. And I will tell you, I don't understand these at all. I know there's an S Corp and there's an LLC. I don't understand the tax implications nor what the differences are. So when you decide to go into business, you're going to want to have those kinds of lawyers. What we're going to be doing at CWI is putting on our website much of this information. So please, cwi.org will have a lot of this information in broad strokes for you and give you the names of the state agencies which sort of lay this out. In addition, the labor and employment law website at the Cornell ILR school, which is a mirror image, will also have this information as well. So come to the CWI website, find it. We're going to be putting up toolkits. In addition, at some point, we're going to be working with community-based organizations and with workforce development organizations and community colleges to do this training. And then we will be filming it and putting it on the CWI website and our website, the LEL website. So you'll be able to go back and keep looking over and over. And there'll also be a list of where to look to get the information. If you find yourself in trouble, if someone has filed an EEO complaint against you, at the State Division of Human Rights, or at the EEOC on the federal level, or it's a wage and hour complaint, please go to a labor and employment lawyer, not the lawyer who's hung out a shingle in the shopping center. Please don't do that. They don't understand the law. So just a very quick why I say that. I used to be a union lawyer, and I remember having to do grievance arbitrations with somebody, and I was representing someone who was discharged. And the same thing happened to me when I was a National Labor Relations Board attorney. And the grievant, the person who felt that they were fired unnecessarily, whether it was a grievance arbitration or the NLRB, and I was representing them as a violation of federal law, they would bring in, quote, their lawyer, a very wonderful, nice person who had no idea what he or she was talking about. They didn't understand unions. They didn't understand collective bargaining. They didn't understand labor and employment law. So if you find yourself in this situation where you've got a labor and employment law issue, please find someone who functions in that, who does that kind of law. Go to your local bar association, and they can give you the names of people who practice labor and employment law. They can also give you names of people who practice corporate law. I would never tell you what kind of corporation to be, because every time somebody explains it to me, I immediately forget it. So I know what I know, and I know what I don't know. So let's go back. But if you have more questions, please let me know. So I want to spend some time talking about harassment. I think this is a really important issue. I was in a meeting with someone who said, well, we know no sexual harassment. I said, right. Do you understand all those pieces? I said, big companies come to us at Cornell all the time for specialized training. And they went, oh, so let's see if I can give you some background. What does it mean, sexual harassment? Remember, it can be any combination. It could be man on man, woman on woman, or woman on man, man on woman. It doesn't matter. It's all sexual harassment. And what does that mean? It means sexual advances. It means sexual advances. It means some sort of request for a sexual favor, like you can get a promotion if you really have the ability to move up in this company. Why don't we go out for dinner and drinks? You know where that's going. You absolutely know whether it's coming either direction, any direction, you know what that means. And so any sort of verbal or physical conduct which makes you understand that this is a sexual ploy here, even including undressing somebody with your eyes, So that's the sexual harassment part. The hostile work environment piece of this. Now that makes a hostile work environment. Let's not say it doesn't. It does. However, you can also have a hostile work environment, which has nothing to do with sexual advances, but has to do with slurs and comments and innuendo and actually using horrible, terrible words, which I will not use even as an example today, which go to somebody's protected status. So their race, their national origin, their gender identity, domestic violence, any of the things here, whether it is about somebody's disability, it's about somebody's religion, it doesn't matter. That kind of slur or comments makes it very clear that it's a hostile work environment. Now, public accommodation. All the things I'm going to say apply when a customer comes into your establishment. So customers, I've seen it where somebody, behind the counter starts flirting and maybe somebody walks by and does a touch. Nope. And you, as the owner of that company, are responsible for your employees' behavior. You are responsible for your supervisor's behavior in an employment situation and in a public accommodation situation. Either one, sexual harassment and hostile environments get played on both sides. Really, really important to sort of keep that in mind. It's always about unwelcome behavior. It always is about creating a feeling that you're being intimidated, that it's offensive, it's hostile. And in the employment situation, if you don't give in, then in fact, your job is in jeopardy. So if you don't submit, you'll lose wages, you won't be promoted, or in some situations, you won't get hired. So what's the test here? What's the test here? The test is really about, does that person, whether we're talking about a customer or we're talking about an employee, does that person feel intimidated? How are they taking this in? The impact on them becomes important. And the assumption is that's part of the test. The second part of the test is that it's a reasonable accommodation. So it's based on how the person affected feels and how a reasonable person would actually sort of behave in this situation. So those are the kinds of things to please think about. Now, federal law says it has to be really, really, really severe and pervasive, not state law. So if I'm on the federal system, then I have to prove that you're driving me nuts all the time. It's not just a one-off. It wasn't just a one-off little comment about what I was wearing that day, but it's constantly talking about you should wear tight sweaters, or your skirt should be shorter, or why do you wear pants all the time? Da 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 da. New York says doesn't have to be so pervasive if I have this feeling that I am being sexually harassed, and a reasonable person would feel that way. So please, this comes from the top. It means it's your business. So you set the standard. You set the way behavior is going to take place in your organization, in where you are in charge. Whether, frankly, you're talking about being in a community-based organization and you're the executive director, or we're talking about you running a dispensary. It comes from the top. It always comes from the top. So let me just give you a couple of examples and then we'll move on. Offensive jokes, slurs, name calling, of course, physical touching and threats, ridicule, mockery, insults, a put down, offensive objects or pictures. I was involved with a lawsuit in which they had a picture that looked just like my plaintiff in that case. And I will tell you, it was disgusting. So while they didn't touch her, they had these offensive pictures that they circulated about her. And it interferes with the person's work performance. So this is kinds of things I want to make sure you're aware of. Again, this could ruin your business. This could ruin your business. The last on my slide here says no retaliation. I will tell you, in some ways, that's the most important thing to know about this area, is I file a complaint that I have been discriminated against because of my sex. It's investigated, and the determination is, no, you weren't. Then you change my office. And this is a real case, actually. This is a real case. Then you change my office from my really nice windowed office, and you put me all the way in the corner where the sun, there's no window. I'm in this terrible, terrible location. I then file another complaint, and the complaint is you've retaliated against me for my first complaint. Now, even if your first complaint is not with merit, it's meritless, your second complaint of retaliation could be good, and the employer could be liable here. So if someone makes a complaint, files a grievance, goes to an administrative agency, goes to, if you're big enough to have an HR department, and some of you will start small, maybe you will have an HR department someday, goes to the HR department and files a complaint, even if it's found to be meritless, if they had a good faith belief that they were being discriminated against, don't then in retaliation put them out in the hinterlands or cut their salary or give them the worst route as a driver, whatever it may be, because that would be a good retaliation claim. And I will tell you that it includes an employee coming to the boss and saying, so-and-so is being treated terribly, and they're making fun of him, her, it, they, whatever. And then that person is then discriminated against by the employer, retaliated against. The federal courts have also taken cases about a fiance. So the one part of this engaged couple makes a complaint, and who do they retaliate against? The other part of the couple, fiance, and the courts have found that that's a violation of the law, that's a violation of the law. So please play it straight, because it can only cause you more trouble, not less trouble. Okay, any more questions about this? I know I'm moving fast. All right, criminal records. Criminal records. We have both federal, New York State, and local laws involved with criminal records discrimination. Now remember, MRTA is expunging people's criminal records, which is really important. It's very, very important. And the whole point here is to make up to a community that has suffered because of mass incarceration, and because indeed this stop and frisk and the talking about cannabis violations under the Controlled Substances Act. So here are the things I want you to think about as employers and as prospective employees and as employees who may be working with somebody who has a criminal record. First of all, you can never on an employment application ever ask if the person was ever arrested. Arrest means nothing. I can be arrested tomorrow. Doesn't mean I'm guilty of anything. So you can never, ever ask about an arrest. Many jurisdictions in New York State, however, not New York State as a whole, we have no New York State law, but many jurisdictions have banned the box limitations on their employment application. That means that when you apply for a job, you cannot have that little box. You can also have it for disability, by the way. Do you have a disability? That used to be up there too. Do you have a criminal record? Have you ever been incarcerated? As an example for New York City, because Buffalo's is different and Rochester's is different, but I'll use New York if that's okay with everyone. New York City says that you cannot ask me about whether I have a criminal record until you've made a conditional offer of employment. Once you do that, then you can ask me, and I can also be asked if and told that you're going to do a background check on me. And often the background check will show up that you indeed have a criminal record. In that situation, first of all, it could be wrong. I will tell you that there are thousands of background screeners out there, and they often get it wrong. They don't get the right information. I was hiring someone, and she doesn't have a criminal record, but I was hiring someone, and part of the requirement was she had to have a master's degree. The background screening company, and believe me, Cornell pays well for its background screeners. They said she didn't have a master's. They couldn't find any evidence of her master's. Guess what? She came into my office with her master's, her framed master's, to prove to me that she had a master's. So they get it wrong. Then you have, as an employee, the right to correct the background of that, the report of that background screener. However, they have no responsibility to tell any of the other thousands of background screeners that there's a mistake. So you're always in this terrible round here that it could come up again and again and again. But what's important in New York State is we have a law that says if indeed, and this is all across New York State, not just New York City, if indeed you are applying for a job and you have a criminal record and the employer finds out about it, the employer has to look at the job that you're applying for and what your criminal record is about, has to look at how old you were, how many years ago was it. There's a series of 8 factors. The ones that I think are most important, which I'll share with you, are 1, job relatedness. Now, I've gone into the prisons many times to teach labor and employment law, and this is the example I use. If you went to prison for animal cruelty, dog fighting, cockfighting, figure out any of these, don't apply for a job with a vet to be a tech in a vet for a vet. Job relatedness. What you went away for is exactly related to the job that you're applying for. Stay as far away as you possibly can from that. In terms of age and how long ago, a quick little example. An 18-year-old young woman was working in this is a true case, was working in a department store. Some people got her involved in a credit card scam. So they were charging people's credit cards for things they weren't buying. Okay, they were found guilty. She made restitution. She did community service. She was a kid. She was 18 years old. She cleaned up her act. She went to community college. She got an associate degree. She decided what she wanted to do was she wanted to be on school buses for children who are disabled, have an aide on those buses. That's what she wanted to do. She wanted to help and work with young children. She took the course. She got the certificate. She applied for the job. Guess what? Rejected because she had a criminal record. The case went to court and the judge said, excuse me, what's the job relatedness between taking care of these children and what she did when she was 18 years old? She's 25 now. She's made restitution. She's shown that she has changed. And you're going to deny her the ability to do this job? And he basically told the Department of Education of the city of New York, you better hire her. So you have age, you have how long ago was this, you have job relatedness, and you have the evidence that the person has changed. So those are the kinds of things to think about in terms of people's criminal records. Now, MRTA is expunging people's records. However, people don't know that their records are being expunged. So this is one of my pet peeves here. You're listening to it live. People don't know what it means. They don't know what's happening to them. There's been no attempt to notify people. Unlike the federal pardon, where they are preparing certificates to go to everyone who's been pardoned, that's not happening. So please tell anybody who has a cannabis record, they have to go to the court and seek a certificate of disposition, which proves that it's been expunged. They should know it. And if it's expunged, then if they ever get asked about whether they have a criminal record, of course, they may have for something else. I'm not speaking about that. They have the right to say, no, I do not have a criminal record. So that's really an important piece here of what MRTA is trying to do. Any questions about criminal records? We've been doing educational programs, helping people understand what expungement means. I will tell you, hiring people who've been involved in the criminal legal system, you're hiring some of the best, most loyal employees you could possibly find. And so I really think this is an important piece in terms of criminal records discrimination, because we know that it was people of color who were arrested. not young white men, it was young Black and Latino men who were arrested and convicted and sent to jail. So you can think about this as a disparate impact case, can't you, in terms of discrimination? Actually, there was one, but I don't think I have time to go into it. At any rate, please remember this. And if you have specific questions about this, please let me know. It's a really important area of the law. So, privacy. Under the New York State labor law, you have protections. The latest protection is the legal use of consumable products now includes cannabis. So it's alcohol, it's cannabis, it's smoking, it's all of those things. But let me make clear, when we're talking about cannabis, you cannot bring it on to the workplace. You cannot smoke it or eat it during lunch. It is from wall to wall. From the time you walk in that door to the time you leave. I know people say, yeah, but people at lunch, sometimes they go out to lunch and maybe they have a beer. Well, maybe they shouldn't, but maybe they do, but that's not an issue. Under the New York State labor law as amended, while an employee cannot be discharged, you cannot test cannabis as an applicant for employment. You can't be discharged if your blood test comes back because who knows, could have been 30 days ago, 25 days ago. The question is going to be impairment. And we have no reliable test for impairment for cannabis. None. None. It's not like a breathalyzer. So right now they're talking about articulable symptoms, but nobody really knows what that means. Nobody knows. So the best we've been able to get is, are you operating dangerous machinery in an unsafe way? Well, I don't know. Maybe your kid cried all night and you're tired. Or maybe you have a cold and you took cold medicine. So this is a whole new developing area of the law. Also, and as an employer, this electronic monitoring, which is happening more and more, if they're monitoring your phone or your computer, you have to be told about it. So that's a really important piece. In addition, your political activities, we are in political activity season here. So this is protections that you have as an employee, and as an employer, your responsibility to make sure that people's rights are protected. Okay, safety. We have OSHA, which is the federal law, and there are also state laws. Overall, just think about the fact that an employer has a responsibility to provide a safe workplace. Think about that. There's a general duties clause, and then there are specific requirements for all different kinds of businesses and activities. But overall, think about a safe workplace. We had the New York State COVID law for a really long time. And there are requirements for safety plans as well. You're going to see the development of more and more safety plans in cannabis. I'm sure of it. I am absolutely sure of it. But I wanted to raise that with you as well. And I know my time is almost up. As a summary, employees are protected by federal, state, local laws. A collective bargaining agreement gives a lot more rights than any of the laws do. That's an important piece. These constantly changing. So please take a step back and think before you act. There's something I wanted to say about collective bargaining agreements, and I hope this is okay. And that is that it really helps both the employer and the employee. So that it sounds very often that it's, well, the employee is getting all of these benefits and rights, but so does the employer. Because not only, as was said earlier, a stable workforce, but I used to call it, when I was a union lawyer, the Bible. And it sat on my desk, that collective bargaining agreement. And I knew what my clients could and could not do, and every employer knew what he or she could or could not do. It is a wonderful document to lay out rights and responsibilities. So it really, in very many ways, is a protection for employers. I think, Eric, someone asked a question about Do they need a lawyer to make sure they don't get themselves? Well, you know what? That doesn't happen when you're following, quote, the Bible.
Good point.
So I just passed that on from my own experience when I practiced law. I don't practice law anymore, so, okay. Lastly, what does everybody want? What does everybody want at the workplace? Respect, inclusion, your voice being heard. Somebody asked me, well, what does affirmation mean and voice mean? I said, sitting at a meeting and giving your opinion and it being heard. That's all it means. That's all it means. Not waiting until you've said it and 5 minutes later, someone who looks different from you says it and everybody goes, oh, isn't that brilliant? That's what voice and affirmation are all about. Fairness, equity, safety, benefits, and decent compensation. That's what labor and employment law is all about. If all of these are happening, you're in good shape. Any last questions? I think I just brought it in on my time.
That was what, first of all, that was absolutely wonderful, Esta. Really, I can't thank you enough. Really brilliant. We do have one quick question.
Sure.
How soon can people get a disposition for records that have been expunged?
Now, all you have to do is go. Now, what they are saying is that you can go to any court in the state and the clerk of the court, you go to the clerk of the court, you pay like $10 and you can get your certificate of disposition. What I'm told by my friends on the ground with boots on the ground is that if you can go to the court where you were sentenced, because the clerk is more likely there to go do the computer search and find the certificate of disposition. It's being handled by the Office of Court Administration, OCA. And so since that's the court, my suggestion is if you can, obviously, if you live in New York City, and you were sentenced in Buffalo, go to a court in New York City. But, if you live in Brooklyn and you were sentenced in Brooklyn, go to Brooklyn, even though you might work in Manhattan. Just because it's easier and quicker. And the clerk, you'll hit a nice clerk and you'll hit a clerk who's not so accommodating. But you can do it now because 400,000 cases have been expunged. So if you think you're one of them, please go check.
Awesome. Thank you so much. Is there any last questions? So let me just my quick summary on what Esta had shared with us. People, you have to go to the CWI website. You have to go to the CWI website. All these little bits of brilliance that we're throwing at you today are all there for free. So absolutely wonderful experience.